So it picks up on the recording?
Hello, everyone. Thanks for coming out today. I'm Jeff. I'm on WUSA's board of directors. So the organization recognizes that housing is a serious issue for all of us students. And so we've been making it a priority in this past term, and we'll continue doing so. This event is one of many initiatives that our fabulous staff have been working on this term. For example, the off-campus housing website has been completely revamped and is on the university's website. And we'll have other things rolling out as well this term. Huge thank you to our fantastic staff. And I'd like to hand things off now to Charlie from Student Care and his team.
Thank you, Bill. Thank you all for coming. At the request of WUSA and also the students, recognize that housing is a big problem, and you have access to a legal support program that gives you, access to lawyers to help you with these issues. And so, in order to link all that, we brought one of the lawyers here from Novum, who's our partner firm, to give you kind of a foundational knowledge of what to expect, what to not accept when signing tenancy deals or looking into renting anything. I'll tell you a little bit more about the program before we start. So it's accessible through the website. If you go to studentcare.ca and put in your WUSA, gives you access to all of the services you have there, and you can do a legal requests form, and it gives you access to 3 components of the program. The first one is a legal consultation component where you can sit down with a lawyer, tell them your story, and they'll be able to tell you if there's any sort of legal situation in there that they can assist with. And nothing is off the table. There's no limits to the areas of law that are covered there. The second component would be a legal representation. And so that's just a step further where the lawyers will actually take actions for you and write letters, negotiate on your behalf, potentially go to the tribunals or court if needed. And those are in housing disputes, employment disputes, and any disputes that you may have with the university. And then finally, there's also a public notary service where you have access to have any documents notarized or commissioned to ensure that it's a valid copy or it's an official document. And so all of that is available to you. It's unlimited, so you can access this as whenever you want, as many times as you want, and there's no limits, there's no out-of-pocket expenses when using it, so it's all included. Whenever you're facing some sort of issue, we highly recommend that you access that and you speak to a lawyer to be able to have some sort of clarity on the situation. I'll stop talking now, but I want to introduce Catherine, who's one of the lawyers here with Novum, who works on the program. Sorry for the slight delay. She was just doing a discovery on our class action case this morning, so we thank her for her presence here and the work that she's going to do and the presentation that she's going to give you. And so, yeah, Catherine, one of the lawyers with us. If there's any questions about the content of the presentation, feel free to ask during. We'll have a floating mic to do that. And then after the session, there'll be the opportunity to have like more of an individual question and answers with Catherine, where you can present your more individual situations and just chat about that whole thing.
Hello, everyone. So hopefully I can answer your questions today. I'll go over like the main subject about housing law. If you have other questions, as Charlie said, at the end we can have a chat. If not, our service is always open for you, so you can just book a call with a lawyer and we'll go over your file, like personal information. So let's start, if I can make that right one. So the housing right. So the RTA, what we refer to the RTA is the Residential Tenancy Act. So overall, what I'll cover today is the actual agreement, so the lease, Also the rights and obligations of the parties, so the landlord as well as tenant. Also the remedies, so any recourses you can take yourself or the landlord to have your rights recognized, so if they're breached, and also what happened at the end of the term of the lease, so we'll go over that. And we also had a special request or subject we wanted to touch base today. So the sublease, or what we call sublet, subtenancy agreement, so it's all the same thing. And it's also assignment of lease, so transfer of lease. Also the big property management companies are a big subject here in Waterloo. I think it's very specific to Waterloo students to deal with those companies. So we'll try to have a bit of information on that as well. So first of all, so I'll refer to the RTA or the lease, but here for the lease, usually everyone that call us will be covered by the RTA, and because they have a proper lease. However, just so you know, there are specific information, specific cases where the RTA doesn't apply. For example, vacation rental, for example, or Airbnb, or you stay over for a couple of weeks or months for short-term rental, it's usually not covered by RTA. Also, the nonprofit housing co-op, the student residence, of course, and also what happens quite frequently is where you share a bathroom or a kitchen with the owner or the owner's child. We also received a few questions, maybe we can discuss about that later, but specifically about that, so that's why I'm raising that up right now, but be sure that I'll address it later. So it's either the owner, the actual owner, or it can be his or her child, parent. So always make sure that you know who you're living with, so to know whether or not you're covered by the RTA. So the form of the lease. In Ontario, since 2018, there is a form provided by the government. It's the document that should be used by your landlord. There's no way around it. And if they do try to use other documents, they're not valid. So they will try, but make sure that you are using the proper form. And sometimes they have like companies, realtor companies renting apartment for an owner in a condo building. So sometimes we see the realtor's form. It's fine if they want to use it, but they also need a proper standard lease. So the little picture here is what like the first page usually look like. And again, everything in the lease is like a 7-8 pages document. Everything is in there. It's very detailed, so you should take time to read it and go over it. Everything is there. So if a landlord tries to put other clauses, other terms that are not already there, for example, I've seen additional like list of fees to cover if you move out or if you break a piece of furniture. This will be the $300 for a couch, for example. So those type of terms, we'll discuss it later, but those are added terms and shouldn't be just taken for granted, and because it's in the lease, we should follow it. It's not as easy as that. And I put the website, but if you just type it on Google, you can get one of those forms. And also, yes, if you're not provided with that form, you can request it. It's your right to do so. And the lender has 21 days to provide you with such documents. So in the lease, usually the rent is the main question. How much are you paying for how long? Is it a monthly fee? Is it a weekly fee? Is it based on your own in a unit, or it's a unit shared with other people and it's the total rent? So always make sure that you know what the rent is. There's a section where it's called total rent or lawful rent, because there's also discount to rent that can be applicable, but we always refer to the lawful rent when we do, for example, rent increase. So that's the number that we should look at. So of course, there are also other charges that they could apply. So the basic rent, and then, for example, for internet, they would charge you a fee of $20 a month, for example. That is allowed. So as I said, discounts are also possible. Now we are over that COVID rent discount, maybe you've heard of, but some landlord would try to attract tenants and offer a COVID discount, which is not a thing, but it's how they called it. And then suddenly so it was like 50% discount, and then suddenly they wanted to raise it back to the 50% more, so the 100% they usually rent it for, but that's not the way it is. I've had a couple of cases of that in students in Waterloo. So of course, like I said, it's not a thing. So we were able to have the LTB, the Landlord Tenant Board, finding her favor, and the landlord couldn't increase the rent. So we should be over that because it was a rent freeze in June 2020. But if you hear of it and you have questions, you're welcome to ask your question. So it must be in writing. Also, the rent increase, as I said, is always applicable on the lawful rent. And the rent increase should always follow the guidelines. So every year, the government provides you, like in January, with a guideline of rent increase. This year, it's 3.5, so it's quite high. Usually, it's around 1 or 2%, but as everything else, the price increased. So the rent increase can only be done 12 months after either you moved in, so you signed a lease, or the last rent increase. So for example, if you come and do just like a 6-month, or I don't have an example, but anyhow, it's really 12 months you have to follow. So they cannot increase the rent just because it's like the beginning of school year and all the students are coming in and they're increasing the rent for everyone and they want to increase you. It's not the way it is. And they also need to use a proper form. This is very important. They cannot just send you an email or a call and say, okay, let's increase your rent. They need to use the N1 form. Just so you know, in Ontario, you are very big on forms in terms of housing law. If you go on the Landlord Tenant Board, there are, I don't know, 25 forms for tenants and 25 forms for landlord. So you must use the right form, of course, but they're pretty good at explaining. They have like a description for each form, how to use them, when, and how to fill them. Of course, we're there to help you out with that. But if you want to go on your own and have a look at that, it's pretty user-friendly. And if the landlord wants to increase the rent more than the guideline, then they have to apply to the LTB. So they have to do the proper legal procedure to get an order from the LTB saying, yes, you can increase. And there are some specific cases where they can, but they cannot ask you to pay that increase over guideline before an order is made. In terms of deposits and other charges, there are some legal and illegal, of course, charges. So the most common and the one that we hear and are legal are the last month rent deposit and the key deposit. So the last month's rent deposit is usually asked when you sign your lease. They say, okay, for example, your monthly rent is $1,000. I would need you to give me a deposit of $1,000 that I will use on your last month rent. It is very important to know that they cannot use that $1,000 of their last month rent deposit on anything else. It's not a security deposit, it's not a damage deposit, it's nothing else than a last month rent deposit. So if you end up not moving in because they decided that the apartment wasn't available, they should give it back to you. Or if because you decide not to move in, they cannot keep it. They can ask you to pay a fee, pay the first month rent, but they cannot just use it because they have it in their bank account. And also, they cannot ask for more than 1 month, or the rental period. So if you're renting for a month to month, usually it's a month. But if a fixed term year, for example, which is the most common, then it's a 1 month rent deposit. The key deposit is for, of course, the key or the fob, depending where you live. Usually it's around $200, maybe $300, but the LTV found that $400 was too high. So usually it's around 200, but they will ask it for every tenant in the unit. So if there are 5 rooms and 5 tenants, they will ask $200 for each tenant. They're allowed to do that as long as they have a lease. Of course, if you lose your key and they need to replace it, they can ask you for a fee, and it must be returned at the end of the lease. There's no way they can keep it because they're not happy with how things turn out, because they think that you damaged something. It's not a security deposit, it's not a damage deposit. They should return it as soon as you return your key. And also the charges that they're allowed, like I mentioned before, if for heat, sometimes furniture, parking, it's all charges that they can charge as long as it's in the lease and you agree with it. So that is legal. And if they ask you to pay other things, you can say no. But also if they don't return those things that they were allowed to ask in the beginning, but when they're supposed to return it, they don't, then you can apply to the LTV. And it's, again, another form, but it's an easy process. Usually what we would do is to send a first letter to the landlord, trying to negotiate, and maybe like half and half, 50% of the time they will return it. They just start trying, and we'll get to that with big company management. Smaller landlord, usually like companies, they will try to keep it and fight it. But then when we get to the LTV, it's pretty easy to win. The illegal charges and deposits is everything else. Everything that it was not on the first slide is not legal. So again, security deposit, damage deposit, children deposit, like anything else, really. I listed like a few that I've heard of, but anything else, you are allowed to say no. They cannot enforce that. And if they try to prevent you from signing a lease and they say, no, you're not signing because you're not accepting that, you can also apply to the LTV. They don't have any right to ask for that. So invalid clauses in the lease, sometimes they try to put a no pet clause, which is not valid. Everybody is allowed to have pets in their unit, as long as there's no disturbance to other tenants in the building. Or it's not like some dogs that are dangerous, for example. But again, the no pets clause won't be valid. So at the beginning, they have to agree for you to move in with your pet. And if they find out that your pet is disturbing other tenants or damaging the property, then they can apply to the LTV to have you either move out or get rid of your pet, whatever you want, but you cannot at first in the lease include that type of clause. Same thing for guests. A landlord cannot prevent you from having guests, roommate, or your other occupant in your unit. They cannot ask you for notification if you have people over. And they charge you fees. I had a case with a no trespass notice that the landlord sent to the lady who was in a situation where between her and her boyfriend at that time, there was violence. So they had a fight, and then she asked the landlord to change the keys, which they did. But then he came back and they got together again. But the landlord tried to enforce a no trespass order on him, involve the police, but it's not valid. There is actually a court decision from the divisional court, which is higher than the LTV, saying that there's no such thing as a landlord asking tenant not to bring people over. And if they do, again, you can apply to the LTV for harassment if they are very insistent. So don't be afraid to have people over. Now, the rights and obligation of the parties. So first thing, the quiet enjoyment. So this is like the main thing we hear usually, that you can use your unit the way you want it, as long as you're not disturbing anyone. And the landlord must also let you live your life in your apartment. And they cannot just say, you can do this or that. So I put the section here of the RTA because it's one of the main one we use when we apply at the LTP. So the landlord shall not at any time during the tenancy to interfere. And the word substantially is quite important because it's maybe a bit of legal stuff, but the board will try to really enforce that. Is it substantial the way that the landlord tried to interfere with you? They just tried to put some rules for like everyone to get along, or was the landlord very insistent on, I don't know, asking for entry every week to check on your apartment if it's in good state, for example. So the quiet enjoyment includes the reasonable privacy. So same thing, if there are cameras in the building, there should be signs. There should be notice and policy on how you can access those recordings. Freedom from unreasonable disturbance, exclusive use of the rental unit as well. And if another tenant is interfering with your rights, then the lender has an obligation. The lender has to make sure that all the tenants can live freely and quietly in the building, so they must take action. Entry in the unit. So usually, unless it's an urgency, a lender must provide a 24 hours notice. And in that notice, they should put, there's no form for this time, it can be a letter or an email, but they should say the reason and also when. So they can put like a time frame, it's fine, but they should say, well, a reasonable time frame, not between today and Friday, but a date and a time. Usually they will enter to make repairs. Even if you ask for the repair, and they want to come and repair it, which is great, they need to provide you with a notice. Inspect or show the rental to possible tenants. They give you a notice. So it's really just in cases of emergency that they can come without notice. And yeah. And by the way, the bed bugs issue, or like those type of bugs, even if you want it to be taken care of as soon as possible, it's not considered an urgency in terms of the notice. So, yes. I'll repeat your question just in case. Could you hear at the back there? No. So if the lender is coming to your unit to do maintenance and they have workers, are they allowed to leave and leave the worker in your unit? Yes, they can, because they're responsible for those workers. So if anything happened, it's the lender's responsibility. So he's liable for those workers. But he should also let you know in the notice, like, okay, we'll come this day, we'll do that type of maintenance, I'll have workers there, and so on. So no, he doesn't need to be there. Because they are considered the lender agent, and the lender is liable for his agent. So it can be a superintendent, the property manager, workers, so it doesn't need to stay. Does it answer your question? So no harassment and discrimination, of course, like anywhere else. And it's, of course, also applicable to both parties and the guests as well. So as much as the lender is responsible for all the tenants in the building, the tenants are also responsible for their guests. So they're allowed to bring guests over and to have roommate, to have occupant of their unit, as long as there's no disturbance to other people or discrimination or harassment. So if you invite someone and they're starting to harass another tenant, then you would be responsible. You couldn't say, well, it was my guest, not me. No, you're responsible. Yes, and the entry without notice could be considered harassment. Like I mentioned, if they come over again and again to look if there are damages or to check on you, and sometimes on bigger unit with multiple rooms and multiple tenants on different leases, they feel that the common area in the unit is their own and they can come over whenever. It's not how it works. They should provide you with a notice. Of course, yes.
Is it okay for a landlord to ask for guarantor funds in case you can't?
The guarantor form is a thing, yes, they can ask for that. It's not considered discrimination if you can, like, for example, usually you're a student, they're not sure if you're gonna have enough income, they can ask for a guarantor form. However, there are some limitations in terms of interaction with that guarantor. They cannot, for example, if you haven't paid, or more specifically, they claim that you owe them money for damage when you moved out. They cannot go after the guarantor and harass that guarantor. They have to go through you. And then if you're not paid, they would apply to the LTV and include you and the guarantor.
No, I mean, like, for example, can they ask 2 months of extra rent? Rent to have in case you can't pay for rent?
Okay, so not a guarantor, not a third party.
Guarantor fund.
A guarantor, no.
Okay.
Well, they can always ask for something and you can always say yes to something if you really want a place. But it's not the basic law. If you want a lease and you don't agree that you should pay that, you could apply to the LTV, get an order saying, no, you only have to pay 1 month. So you cannot be pressured into a lease with 2 months rent, for example. But if you really want it, you can accept to pay the 2 months rent. So at that point, it's more a consent thing than an obligation based on the RTA. You understand like the difference?
It's not like a rent.
No, it's not a rent deposit. At that point, it's really just, I think, to guarantee that you're gonna pay, or kind of a security deposit. Like I said, it's not legal to put that as a condition in the lease. They cannot enforce that. But if they ask you and you agree to do it, then you agree to do it. But if they put pressure on you to pay it and you don't want to, you don't have to pay. Once you've paid, do you still live there? Well, usually if they ask you to pay deposit, they should apply it to a monthly rent or give you back the money when you move out. So now that you're no longer there, it would be more that this way would work. See what I mean?
A company that they keep doing this, asking it's like legal to pay them.
Yes, that's why I wanted to touch base the management company, like here in Waterloo. Those companies usually do that. If you don't mind, I'll keep your question and I'll answer it later. That's also why I want to go through those basics of housing law. So now you know that it's not valid. So the next time if it happens, you can fight back. But then I'll also tell you specifically how to, or just some tips on how to deal with those companies. So are you okay if I keep a pin on your questions? I think there was another question over there. No, it's okay. Another type of harassment is all the services, like the basic services like heating, they cannot just say, decide to stop the heating in your apartment, turn it off because you didn't pay your rent. It's not legal. Of course, you should pay your rent, but they cannot do that. Okay, maintenance and repairs. So the landlord must maintain the rental unit in good repair and comply with the health, safety, so all the bugs and insects and other things, they should prevent that because it's part of, in every city, usually there is a bylaw about health and safety. So it's not just the RTA, but it's also bylaws. Sorry. And also, if in your lease you included, it was included, for example, furniture and the oven break, then they should come and repair because it's part of your lease and they're responsible for that. However, the tenant is responsible to any undue damage. So I put that like here, a little cloud with undue damage because it's the main term we use or deal with when we apply to the LTV. Is it willfully or negligently caused by the tenant? So it does not include damages resulting, oh my God, there's a typo there, resulting from normal use over time. So again, if you live in an apartment and you scratch a wall when you move out, it's normal use. You weren't neglectful, you weren't willfully causing damages. However, if you do a big party and then someone hit the wall, then you're on the hook. Of course, to keep the unit clean as much as you can. And you have to pay your rent even if there are damages. So same way, the landlord cannot cut off your services because you didn't pay your rent. But even if they're not coming and doing the maintenance, you have to pay your rent. You have other ways to deal with that, including filing a claim with the LTV, but you cannot just stop paying your rent. And specifically on bed bugs and other insects, you should cooperate with your landlord. So you must tell the landlord as soon as you notice something, but they are responsible for treating the apartment. But they have, like I mentioned before, they have to give you the notice. And you have to prepare the unit. So usually if it's a bed bugs, you have to remove your clothes or whatever. You have to do it yourself, but then the tenant and the landlord has to make sure that everything is treated and cover the cost. Excuse me. And they can, sometimes landlord will try to address the issue themselves. Sometimes it works, most of the time it doesn't. They're allowed to try it once themselves, but just trying is not enough. So if they say, well, I tried and it didn't work, that's not the end. You can ask for them to hire professionals. And if they don't, and even if they do and it comes back, they are always responsible to making sure that there's no insects or pests in your unit. So what we call an application of results. So it's the end, like the end result that is important. It's not how many times you've tried and how in good faith you've tried. It's an application of result all about maintenance and repairs. So the parties' remedies if their rights are breached. So the landlord, he can, if for example the rent is due, he can apply to the LTB, so the landlord tenant board, with a specific form asking for rent payment. He can just ask for rent payment. They don't have to ask for eviction necessarily. Usually it comes with it, but it's not necessarily going together. So also for damages, like I mentioned before, if you're doing a big party, a wall is damaged, then they have to repair it, but they can ask you to pay for it. And if you don't, they can file a claim at the LTV asking you to reimburse those damages. And eviction is usually the main recourse the landlords will use. There again, specific forms with notice. I won't go over all the details, but they can do that to enforce their rights. But be aware, that's another thing with the deposit. It's not because you're receiving an eviction notice that you have to leave. Unless there's an order from the LTV, you can't stay. And now, right now, the delays at the LTV are like 1-2 years on the road. So you have 1-2 years to stay in your apartment as long as there's no order. And actually, sadly, for some landlords, they have bad tenants and they're not paying. And because of the delays, they have bad tenants staying in the apartment and they can evict them. But I am sure you're all good tenants and you pay your rent. So don't be afraid to stay in your unit. They cannot enforce eviction notice unless there is an order. And what about you guys, the tenants? You can seek different order, again, with different forms. For example, if there are maintenance issue and they're not dealing with it, then you can file a form to make the landlord do whatever repairs is needed. Again, delays. So I don't know, that's what is a bit frustrating right now, because if there are, like, for example, like there are big damages in the unit or repairs that need to be done because it's an old building, you have to wait like a year to have it repaired, so sometimes it's a bit frustrating, but you can technically apply. So that's also why we try to send a letter and get into like some discussion with the landlord to make them do whatever they need to do. Also, in your claim, you can ask for either rent abatement or rent reduction. What's the difference? One is more a percentage. For example, again, damages in your unit, you couldn't use your bathroom for a week because the sink and the bathtub and all the plumbing didn't work. Then you could ask for 20, 25% reduction of your abatement of your rent for that week. The rent reduction is more if at the beginning you sign a lease with a parking spot and your lease included a parking spot, and because of that your lease was $700 a month. But now they've decided there's no longer a parking spot for you, so you can ask for a rent reduction permanently of $100, which is maybe the cost of a parking lot, and now pay every month $600. So those are claims that you can also make at the LTV. And what we call general damages is sometimes it's not very high what you can get at the LTV, but still it's something you can ask for. All the stress, trouble, for example, the bed bugs you have to deal with, and every time you have to clean your apartment, make sure everything is prepared, and they come back and it doesn't work, and those things. Time limitation, very important. Most of the claim, although I won't go into details, but most of the claim, remember that it's 1 year. You have 1 year after the day the conduct happened. So if it's a damage, harassment, but if it's a continuing conduct, for example, harassment, or the landlord keep coming in your apartment without giving you the notice, then the 1 year would kind of be paused during that time. So keep that in mind when you want to file a claim. The rental housing enforcement unit is always something you can use if you have very bad behaving landlord. The Human Rights Tribunal for discrimination, and the small claims court is for all the people that are not under the RTA. So the one I was mentioning at the beginning, for example, sharing with the owner the kitchen, bathroom, you still have a claim, you still have rights, you have contractual rights, but it would be under the contractual law at the small claims court. So what will happen at the end of the term? So again, you have options, you don't have to leave. So you can either renew your lease. Well, in two ways. Either it will renew by itself automatically if you stay there. There's no notice given either by the tenant or the landlord. It will, for example, a year fixed term lease will automatically renew to a month to month. So you can stay there and the same terms of the lease apply, but now instead of a year, it's a month to month. So you don't have to leave, even if there's a date on the form. And you can also decide to sign a new lease. You have no obligation to do so, but you could decide to sign a new lease if you want to renew some terms in the agreement, add stuff, but both parties must agree. The landlord cannot enforce that on you to sign a new lease. The same thing is the same lease will apply to the month to month. You can also terminate the lease, so either by the tenant, the landlord, or mutual agreement. So if it's by the tenant, you have to file a form, send a form to the landlord. You cannot, like I said, just wait the end of the term, because you'll then switch to a month-to-month, so you have to give the proper notice. And that proper notice is the N9 form, and you have to give it at least 60 days before the end of the term. So if it's a year term, then it's 60 days before that day. Or if it's a month-to-month, then it would be a month before the month you're staying in. By the landlord, other forms are available for the landlords. They have, I think, 10 types of forms for a different reason. They can, it's either because you were at fault, so it would be an eviction at that point. So they would like to terminate your lease because you didn't follow or you breach your obligations. Or they can also ask you to move out if they need to do big renovations. But be careful with that again, stay in until there's an order, because sometimes there are companies out there, they try to use that to kick out tenants. So they pretend they'll do big renovation, or they actually do, but then it's just to be able to increase the rent. Or if they, so those are the repairs, or the use of immediate family. So either their kids moving in town, they go to university, they want to get the apartment for them. Notice the proper firm needs to be used. And you can see compensation as well. So if they need to use it for their kids, you can say, yes, I will agree to it with the proper firm, but you will pay me for the moving expenses and a month rent, for example. So you can negotiate compensation on that. And by mutual agreement, of course, if both parties want to end the tenancy, there's a form, but there's no delay. You can decide both parties to end the tenancy tomorrow morning. However, the N11 form, lots of big companies use it, and they have you sign it when you sign the lease at the beginning. So the fixed term of 1 year, they kind of make sure when you start that you're going to leave when it ends. So that way they can plan on renting the place to the next tenant way in advance. It's okay if you agree to it and you already plan to move out. However, they cannot force you to sign those forms in order to be able to sign the lease. That's not legal. They cannot already ask you to move out at a specific date because you're allowed to stay as long as you want.
Hi. So on the previous slide, there was a point about needs the unit for themselves or an immediate family member. So in that case, if the landlord informs you that they need the unit for themselves or a family member, how long before do they need to give like a notice for eviction or like just moving out?
Yeah, usually it's also 60 days, but depending on the firm, sometimes for big renovation, for example, where you have to leave for a long time, but you can't come back, it's longer. It's between 60 and 90 days, depending. But roughly it's about that. But they have to provide you the form, and sometimes you wonder if they really are moving someone from their family, so you can fight back and wait for an order from the LTB, which make you wait way longer than the 60 days or 90 days that is provided by the law.
We need to prove that a kid is moving in.
Well, you can ask if you want to challenge them and see if they're in good faith. But no, technically they don't have to prove it. If you agree to it, no. So subtenancy and assignment, those are like the specific subject I decided to present you because I think it's something that is pretty common here with co-op students, international students being here just for a semester, just a few months. So first of all, I wanted you to understand who is who. So of course we know who the landlord and the tenants are, but the subtenant and the assignee. So you see a bit of the picture, but we'll go through all the details. Again, this will be available if you want to go through all the definition. But as you can see with so in here it would be the subtenancy. So the lender and the tenant have like a contractual relationship, and the subtenant and tenant also has a contractual relationship. While here between the tenant and the assignee, which is when you transfer your lease, there's no longer any, so it's like a new lease here. So depending on your situation, it must be considered, because if you don't want any trouble, you don't want to go back, you just want to end your, for example, you're in a case where you sign a lease for 1 year. After 6 months, you decide you want to move back somewhere else. So you're now on the hook for 6 more months for your lease. So you can either ask your lender if they want to terminate your lease. Most likely they will say no because they won't want to lose money. So what are your options? You can either sublet your lease or assign your lease, transfer your lease. The subtenancy is interesting if you plan on coming back. If you're just gone for a semester away, or it's summertime and you're going back home, that could be interesting because you keep your lease, you keep the terms of your lease, you keep the place that you like, but still you have money coming in and you don't have to cover the rent. But however, you have obligations on, and we'll touch base on that. But if you're just going and you no longer have to take care of that apartment, you don't care what happened with it, you can assign it. So if the landlord doesn't want you to terminate your lease, then you can say, okay, I'll transfer it to someone else. And they cannot say no to that. Well, if they find out that a potential tenant is not a good payer, they could say no. But they cannot just refrain from accepting those conditions just because. What do you mean if it's the same thing for a group
Like
lease?
you can, if the lease is shared between 4 or 5 people, can one person just transfer their own spot of the lease to another person?
That is more difficult because if it's one lease, it's one contract. So it would be among you guys to decide, okay, are we okay if that person is not there for the summer and that person wants to rent his or her room? It would be among you, and it wouldn't be considered a subtenancy. It would be more like a roommate agreement, and we'll get to that because in a subtenancy, the tenant has to move out. And in this case, since the group and all the tenants are part of one contract, they would all need to move out. So that wouldn't apply, but you can do that. It's not just a subtenancy, just a contract. So, like I said, the subtenant. Okay, I got it. Okay, so in the subtenancy, the original tenant that we call the head tenant will decide to find someone, and like I said, sublet their room or unit to someone else. There are 4 conditions, however, and all 4 of them needs to be met. So for example, for the first one is that the tenant has to move out. The tenant can stay while the subtenant is there. Then it must, like the new subtenancy agreement must be, the term must be less than the term of the lease. So if your lease ends on August 28th, you cannot do until August 28th or August 29th. It has to be August 27th. And then you must obtain, you need to want to go back, or you can go back whenever you want. So the third condition there, to the right to resume occupancy, as I said, usually you use subtenancy agreement when you want to go back to that unit. And the last one, which is very important, is the landlord's consent. So here you see that it must obtain, which for the assignment, you'll see the words are different. So this one, you really need to obtain the consent. You cannot just ask for it, they say no, and do it whatever. You need to obtain their consent. However, the landlord cannot just say no because as I said. So shall not arbitrarily or unreasonably withhold consent. And if that happens, you can file a claim at the LTV to get consent. Again, because of the delays, it's not really practical right now. But in terms of law and your rights, you can do that. So if you do it without the lender's consent and the lender finds out, then the lender can file for an eviction. So make sure that you have the consent. Maybe they won't find out, but it's at your own risk. So as I showed you here, there's still obligations. So the tenant, which would be you, is really in the middle of two contractual relationships. So you have obligation with the lender and you have obligation with the subtenant. So it's more trouble than an assignment, but if it's for a short term, it might be worth it. Of course, the relationship with your lender is the same. Everything we've already discussed is the same. With the subtenant, there are only certain sections of the RTA that will apply. So it's not exactly a lender and tenant relationship. So there's only some section, including the rent. So if the subtenant doesn't pay the rent, then you could apply to the LTV as a landlord for rent payment or rent due. Same thing with the damages. If the subtenant damaged the unit, you could file a claim against the subtenant to have those expenses reimbursed. But you are liable towards the landlord. So if the landlord finds out and the subtenant left and you can find the subtenant, then they could ask you to pay and you would have to pay. Same thing if there's disturbance. So the quiet enjoyment we discussed prior. If the subtenant is not following those rules, then you could be on the hook. The subtenant, however, is not liable towards the lender. There's no relationship at all. They don't have to talk. They don't have any obligation. They're not liable. The subtenant is only liable to the head tenant. So you, if you decide to sublease your place. And again, only certain rights are covered for subtenants. And actually, it's mainly the money collected illegally. So head tenant cannot ask for those deposits or invalid charges that a lender is not allowed to ask for. A head tenant is not allowed either. So you could file a claim as a subtenant saying, they asked me for a pet deposit because I brought my cat and they asked me for $50 more a month. Yes.
Who would determine the monthly rent for a subtenant? Would it be the head tenant or would it be the landlord?
Would be the head tenant because there's no obligation with the lender. Lender is not at all involved. So it would be the head tenant. And on that, the head tenant is quite, like, it's quite large. They can mostly do whatever. Again, it's up to the subtenant whether that person wants to pay for that or not. As long as they're not charging other type of charges or deposits, but the rent itself, they can ask sometimes for more. Basically, kind of a new agreement between those two. Yes. Just a sec, he's coming with the mic.
What's an example of a reasonable excuse a landlord could give to withhold consent from you subletting?
Question. Since usually it's pretty limited in the subtenancy because, sorry, I can't see, because since there's no obligation between the lender and the subtenant, worst case, if the subtenant doesn't pay, damage a unit, the head tenant is on the hook. So he has someone to go after if something turns out not in his advantage. So there's not pretty much like, unless maybe, I don't know, like a criminal record maybe, but even then, like, it doesn't have really a say on who's gonna live there as a subtenant. It's just, do you agree to a subtenancy? And then you, on your own, you'll find someone. However, for the assignment, which we'll see after that one, there's more implication, because now there's the new tenant is actually like involved and liable to the landlord. And also, I think, in my opinion, I think that's why the RTA says provides, use the word obtain, must obtain, because it's easier to obtain consent when there's no implication to saying yes to a subtenancy for landlord, while for the assignment, it's, well, we can switch now, it's must seek consent. So you have to ask. Then if they say no, you have other like recourses and there's other way around, but you don't need to obtain it properly. So the assignment, the lease transfer, back to my, so here, the lease transfer, as you see, between you, if you're the tenant, if you transfer your lease, there's no obligation between you and the new person. And the lender is now dealing directly with that new person. So it's really the end of your contractual relationship, the end of the lease for you. And there's only one condition for that one, and it's to seek consent. So it can be either general, so hey landlord, do you agree that I assign my lease? Or hey landlord, or specific, hey landlord, can I assign my lease to this person? So the lender can refuse consent if, as I mentioned before, for example, criminal record, or in terms of, I don't know, so if it's not a good payer or they have a bad record, or like those type of reasons why you yourself, to begin with, you could have been refused for a lease. But they cannot consent, they cannot refuse to consent to the assignment in general, just the fact that it's an assignment, you want to transfer your lease, they cannot say, no, here we don't do that. It's not a thing. And if they do refuse, then you have other options. You can send, excuse me, you can send a request to consent in writing, and then if they say no, or they refuse, or they don't get back to you, I didn't put there, I go by memory, I think it's 7 days. After 7 days, if they haven't replied, or if they didn't get back to you within 7 days, you ask for consent, then you can send a notice of termination. So the termination of the lease, those notice we mentioned before, you can send that within 30 days of your request to seek consent, and then you can leave. So the original tenant, you, who is leaving, is only liable for what happened while you were living there. So as the date of the transfer, moving on, you're no longer liable for anything happening after that. So there's no ongoing obligation. So it's easier if you don't plan on coming back to go with that. So you really steps into the shoes, the assignee, so the new tenant step into your shoes. Yes, important, it's the same lease. So it's not a new agreement. The subtenancy agreement is a new agreement, while the assignment of lease, it's the same lease. So the same rent, same term, same everything. So it's really just a transfer. You use the paper, you change the name on it, and it's the same thing. So sometimes the lender doesn't like that because they cannot increase the rent. So that could be a reason why they try to hold consent, withhold consent and say, no, I don't want you to sign, or try to get back to you. but because it's the way for them. Well, for you and as students, if you keep transferring lease year after year, you keep the rent pretty low. While if for a landlord, they end the tenancy, then they can rent it back for a higher price.
They charge you a lease termination fee or a lease transfer fee?
Yeah, the fees are pretty limited in terms of what they can ask for. Usually it's just like basic fees, like if they, for the assignment, if they have to do a credit check, like that $50 or ish money they have to spend on a credit check, they can charge you that. But if they have internal admin fees, they cannot. Or just a fee for assignment, for example, it's not a thing. Okay, the last one. So, yeah, oh, sorry.
So this is about like the clauses. So like earlier in the presentation, I have a question. So you're saying that on a lease, there's not allowed to be like saying no guests, but I've seen like on certain clauses saying no parties. Is that allowed?
No. I think what it goes into like no parties. I don't know if it's they don't want you to have people over or they don't want the loud noise coming with parties and possible damages. They cannot prevent or ask you not to do something before it happens. As long as you can have a party and not damaging anything and not disturbing anyone. So as long as you're doing it within those other rights and obligations you have, you can do it. You can have a party. So they cannot, at the beginning, right in the beginning, ask you not to have a party. Same thing a bit similarly to the no pets clause. You cannot say at the beginning you can't have a pet. But during the tenancy, if they have issues with the pet, then they can ask you to get rid of it or move out. So at the beginning, no, it wouldn't be considered valid.
So basically, like they could just basically say like no noise or whatever, but they can't say no parties.
Yes, and the no noise, it's part of the law, the RTA, and it's not no noise, it's more like the quiet enjoyment, so you're not disturbing anyone like at 2 o'clock in the morning with loud music. Again, if it happens once, they won't evict you or send you no eviction notice for that. If it happens more and more, then they could take action. So the no party clause is not something that they could, well, if they want to put it, they cannot enforce it. It's not valid.
Yeah, I've seen it a lot, and it's like kind of annoying because it's so vague. But thank you for helping with my question.
You're welcome. So the big property management companies, I won't name them, but we all know who they are. We mainly dealt with those companies, with all the students here in Waterloo, all the files we have, all that I personally had. I'd say 90% are with those companies. So they have scare tactics for students. They know that they're dealing with students. They know they're dealing with lots of international students. So a mix of that is a lot of people not necessarily knowing their rights and easily scared away. So they use everything they can as big companies to do long contract, like the lease. Yes, they use a form, but then add pages and pages of conditions and additional fees. For instance, the furnitures or paint fees or move-out fees. So all of those things, as we said, are not valid. Or so if they're putting it in the lease, fine. Like you don't have to fight back. If for now you don't have to pay anything. But if they try to enforce it, then you can say no, and you should say no. And as I said, as long as they don't have an order from the LTE, they cannot force you to pay a damage fee. They cannot force you to leave the unit. So I think what I want you to remember from today's conference or presentation is that you should say no before saying yes. Because once you say yes, okay, I'll pay that fee because I'm scared away. They're now the collection agencies after me. They sent me a multiple notice, they called me, and they said that they would take legal action against me. So I'm scared, I'm gonna pay the $1,000. Then you call us. It's way harder, not impossible, we'll do it. And it can be done like legally. But I mean, it's longer and harder for you to get back that money because then we have to apply to the LTV. And then we have to deal with the agency company saying, stop calling our clients. And we have to wait a year and a half to get back that money. We'll get it back at the end, but it's a long process. Well, if you say no at the beginning, when they ask you to pay it, you call us, and then right away we can interact with them and say, what you're asking is not legal, it's invalid, so please stop. And if you want, you really think they owe you that money, then file a claim with the LTV. And usually it stops there. So you should call us before saying yes to any type of payments with those big property management companies. Same thing with collection agencies. It's their tactic. They will call you multiple times, send you emails, but as soon as we send them a letter and email, they suddenly stop. And we don't hear from them at any point, and then we deal with the landlord directly. Yes?
If you sign a lease and with the fees on the lease, are you still obligated to pay after?
That's a good question. The landlord will say, and those companies will say that it's part of the contract, so you should follow it. However, the RTA provides that any other terms that are not provided provided by the RTA that is against what is provided by the RTA is not valid. Therefore, our opinion and what we've presented before the LTV so far, and which worked in most cases, is that if those fees are not valid because they are not based on actual undue damages. So the RTA say it needs to be undue damages for the tenant to reimburse those fees. So if they're not, they cannot put those fees. However, if you caused the damages because you were negligent and they decided that a broken piece of furniture is $300 and it was your fault, then yes, it would be that amount that you would have to pay. But as long as it's not undue damages, our position is that you're not owing that money.
There is no clear way to prove because undue damages. Like for example, they claim you left broken glass in the, and that's what you claimed, but you didn't.
No, undue damages are like a fire. Like you use like a knife and started to cut off like all the couches in the apartment. It has to be like some level of like negligence or willfulness in your action. So that's why like the day-to-day wear and tear, a broken glass, like it happens. Like it's not undue damages. And the fact also it's when they ask like for little things like that, they ask like $200. Like at least if they would ask $20, maybe it would be more reasonable and we would think about it twice. But it's just nonsense. Like the amount also have to match the actual damages. So it's also a claim we make. If you're telling the lender, if you think it's undue damages and it was negligently caused by your client, then fine, prove it and provide us with the receipt of how much you paid to replace the couch, for example. And usually they either didn't replace it because we have pictures of tenants now living in the unit showing that it's the same couch as there, or they replace it with a spare couch they had in the basement that is also old but that's scratched in the same place. So it's also something we can do to fight back by saying fine, but provide us with receipts. And usually they don't have those receipts. So for me, it covers pretty much everything. As Charlie mentioned before, student care is there for you, Novum is there for you, I mentioned that the big companies, but any type of issues you have, it's always better to prevent it than to try to fix it. You have rights, so we always find a way, but it's way easier, and mainly because of the rights at the LTB, it's way easier to try to prevent them getting to interaction with the companies. As I said, we're dealing a lot with them, so now we know exactly who the paralegals are. We email them directly and say, hey, my client just sent me that. Can we deal with the issue? And usually we no longer really have to formal them in a letter, or if we do, we just send it to the personal email of the paralegal and even the company's email. So we are getting like used to it. So that would really be my recommendation, to get to us, call us before you sign something if you're not sure, or before paying something if you're not sure. That will help you a lot in terms of saving time because of the delays at the LTB. So I think we are at the question part, if there are still questions. Oh, I think so.
So we have a question period that will start right away. Jill.
Crazy timing, your bike is dead.
Okay, so how we're going to move forward with the next section is we're going to do a Q&A, but we're also going to make sure you get fed for this session. So if you folks would like to eat now, we're going to use these sticky notes as a coupon that you showed up, you attended, and you listened to this session. At the doors in the back, you'll be receiving one of those. Food will be served by staff, but we also encourage you to stay, continue to ask your questions, and remind yourself that Student Care, the legal program, is here to help out with the one-on-one situations or continue to support you. So right now, you can grab food or continue to ask some questions.
Wonderful thing about this program, all these forms and every step that Catherine was talking about, you don't have to remember. All you have to do is contact or access the program, and lawyers like Catherine and other partners out will do this with you, and they'll be responsible for remembering that. So the N90 form and all that stuff, don't worry about that. All you have to do is explain your situation to the lawyers, and they will do whatever else is necessary along with you to fix your problems. And this applies to housing, but it applies to employment, it applies to any issues you may have with Waterloo, or anything else that you may experience as well. So that's really the beauty of it, and that's why we want you to know about it. You have access to it. There's QR codes, you can go to the website. And so, as Catherine mentioned, prevention is always easier, but that doesn't mean that we can't do anything about it. But yeah, go get fed, ask questions. I'll pass the mic around, even though we have only one, and yeah. And if you want to clap, you can clap.
Thanks for your presentation, Catherine. I just have a quick question about the rental takeover or transfer of the lease. So let's say before that was enacted, last month's deposit will have to be applied to the shorter ended lease. Now that there's a new, does that work?
Yeah, that's a good question. As I said, that deposit has to be used for the last month of rent. In case of a transfer, technically your rent or your lease ends the last month before the transfer. So I would say that that would apply to that last month before you move out, and the assignee, the new tenant, would then have to pay their own last month rent.
If a company, if you paid for example, a key deposit, but that they never returned it, and it's been like 2 years since you paid it, what can you do? Is that money, can you get it back?
Maybe I can just speak loudly.
Yeah, but we can just talk loudly, it'll be easier.
Yeah, you can pass around that. As I said, you have a 1 year time limitation. So the 2 year, you would be past that 1 year, so you can't do anything about it. if they owe you that money and you moved out. Would that be the case, for example? Yes. So that would be too late. However, if it's a year less 1 day, tomorrow is the 1 year mark, you call us today, we can file a claim before that 1 year.
When does the 1 year start? Does it start when you pay? The 1 year start when you pay the key deposit or when you moved out?
When you moved out,
Oh, okay.
when you return the keys.
Okay.
On the contract, they said I can't hang anything, can't tape anything up. So just to make sure I can do that and it wouldn't be considered undue damage.
Yes, it won't be undue damage. Can you hear me if I speak louder? Okay. Consider undue damage. I saw even smaller companies are like landlord, renting their own condo, for example. Hello? Okay, yeah, renting their own place and they want to make sure there's no scratch on the walls and they put that, but it's not valid because it's not undue damage. So for example, if you do hang a frame, move out and they see that little hole and they ask you $100 for it, and say, well, it was in the lease, you weren't allowed to put up frames, don't pay it. So ask them to file a claim at the LTV if they really think you owe that money.
So what happens if there is a change in ownership, like if the landlord decides to maybe like sell the place, so do we have to move out or is there like a new rental agreement and the rent goes up, like what happens?
Yeah, it's a good question because it happens often or just it's the same owners like companies owning a big building but then a new company, a management company coming in. And so either that or a new owner actually like selling the place and having a new owner. The lease stay the same, and you don't have to move out. So new owners buying a new place, a new building, they have to take it with the lease in place. So sometimes there's like a trend now that big companies are buying those buildings, old buildings, trying to evict everyone, to renovate them, and then increase the rent. And so make more money. So, but then, even if they wanted to try that, they would have to file for an eviction notice. So it's not because there's a new owner or a new company, management company taking over, that the lease ends, that you have to move out. Everything is the same for you. And if they try to say otherwise, it's not right. So again, another example would be a new owner and they want to use that building for their children. It's like a 6-unit building and they want to kick you out, the 6 tenants, because they want to have their 6 children move in. They could, but they would have to either send you the proper notice, you could refuse, and then they would need to get an order from the LTV.
So
if you refuse us.
oh, I see.
Yeah, anything our landlord asks you to do, if you say no, their only way out is the LTV. And with the delays right now, it's a long time.
Thank you.
So this question was actually, I got like a 30-second intro on it, but I guess there is a student who has had another student that they gave money to, I guess planning to sublease a space from that individual, and then they went to move in and the person said no. Can they go, does the legal protection program help that student? Could they be connected with you folks?
So yes, we would, of course, would be covered. And to briefly answer the question, if I understand correctly, is it the subtenant who was told no, or the tenant who was told no by the lender?
I don't actually know.
Okay.
I literally got it. They couldn't.
Okay, so if it was the lender saying no, right before the subtenant moves in, it's because the head tenant, so the main tenant, didn't follow the proper process of one of the conditions, obtaining consent. So yes, the lender can say no. If it's the subtenant trying to move in and suddenly the head tenant says, no, I don't want you to move in. Like I said, the RTA is pretty limited in terms of protection for the subtenants. It would only be for the fees, so the subtenant would most likely be stuck. They could file a claim at a small claims court for like a breach of their contractual relationship or the breach of the contract. But again, you want to wait 2 years for a 2-month storm during the summer? Probably not. So you go and find another place, sadly.
Thank you.
So, because of course there's what you can do, like what the law provides, but also practically what makes sense.
Are the slides going to be shared with us?
Yes.
Where can we find them?
We'll send them to the association.
Back, you're like covered through like the student care program.
Well, Charlie can answer.
So everything that's covered through the program is essentially everything that Catherine described. So any issue that you may experience in terms of housing, everything, as much time as you interact with the lawyer and the lawyer works on your file, it's all included in the file, no extra, or the program, no extra cost at any point. So if you want to submit your lease for review, you can do that, and it's included. So the first component, the legal consultation, you can talk to your lawyer about any topic. Like there's no limits of what it can do. So I don't know, you witness some sort of fight at a bar and you want to know, do I have an obligation to report or to write a statement, or what should I do? You can ask a lawyer. And when it comes to housing, employment, and academic disputes, that's where it goes that step further, and the lawyer really isn't like your lawyer, where they act on your behalf. They can negotiate with the landlord or your employer or the school, write letters, ultimately go to the LTV,
Yes.
Yep, and file those motions. So that's all included in the, so it's a prepaid fee that at the beginning of the year is on your tuition sheet. You can opt out if you'd like. But after that prepaid fee, everything else is included, unlimited, as often as you want, as long as needed. So if your housing situation takes, I don't know, 6 months to resolve, and the lawyer spends, I don't know, 1,000 hours on it, it doesn't cost you anything extra. Yeah.
Yeah, and if I can add, as long as you open your file while you were a student, even if, like I said, delays are super long on the LTV and turn out that we go to the board like in 2 years from now and you're no longer a student, you're still covered, there's no extra fee, because you open your file and you started while you were covered by the program as a student.
Hi. Actually, if we are sharing a room with the other guy, and if I mean something like the other guy is like leaving the room, and does the landlord has that kind of an option, like she can get he or she can get another roommate, or will she be forcing me to take the entire room for, I mean, single occupancy? I mean, they can be.
Well, it depends what your lease is. Is it a lease with that other roommate, or you have 2 separate leases?
We have 2 separate leases actually.
So in that case, you're responsible for your own lease. You have a rent, whether there's another person in the unit paying more money or not, you're just liable for your rent. They cannot increase more than the guideline because suddenly it's vacant, then they can find another roommate. They can't do that.
I have a 1-year contract. Can I end?
If you can terminate the contract, right?
Can I terminate it?
Well, it depends when your term ends. So as I said, the termination will be in my form. it would be, you have to notify the lender 60 days before the end of the term. So it's basically saying, at the end of the term, I'm moving. You have to complete the year, if in your case, it's a 1-year lease. If you want to move out before, at the 6-month mark, for example, you can't do that in line form. You would have other options, either mutual agreement, you speak with your landlord and you both agree that it's fine, I'll move out anyway. Maybe it's a new semester and the lender can easily find a new tenant and even increase the rent and it's totally going to be fine with it. Or they'll say, no, you're still liable until the end of the term. Then you would have the option to either keep paying it while not living there, sublet it, or assign your lease. If you're not planning on going back, I would recommend to sign your lease, to transfer your lease. So find a new tenant to take over your lease.
A platform to resolve issues case by case rather than
Not really. Well, recently, I mean, the past year, the LTV tried to go more like on an online portal, and through that portal, they offer mediation, but it's pretty recent. So any other option would be like negotiation between a lawyer or any other representative, or it could be yourself and the landlord. There's no other way to enforce any obligation on a landlord who doesn't behave. Question? Oh, okay, like to know in advance if it's a good company or not, you mean?
my issues with the tenant board, but usually so is there a way for our current students can
That's a good question. Well, mainly today, I think it's one step forward for that type of thing, to make people aware of those behavior out there, of their rights. Like, people need to know their rights in order to fight back, and eventually, hopefully, those companies will try less to do those things because they know that they'll be pushed back from the tenants. So this presentation today is one of the way we can try to avoid that in the future, of course, by talking with other people. And unfortunately, maybe with the online portal, things will change, but with the landlord tenant board, compared to other court or tribunal, the decision that they make are not advertised, or not like Candy. I don't know if you know that website. Candy is a website where you can find decision from any courts in Canada, any type of law, see, even look by name if the company was sued for whatever. So usually we could do that for other type of cases, see if they were, they had order against them. But with the LTV, they don't really do that. So it's hard, because I've tried myself. I had the same thought as you, like, can we go online and see if there are other cases against those companies? But it's not out there, it's not advertised. So maybe it will be really by just talking about it among you guys, having presentation. And unfortunately, we cannot like just post on the student care website, be aware of those companies and name them, because that would be defamation and a whole other type of legal problem we would have. But I think we all know who they are. So now at least you know your rights. And yeah, and maybe there are blogs out there, I don't know, maybe you can do like student groups and share your experience and your do and don'ts, and I don't know. Any suggestions on that?
And also having programs like this one where you have the tools to, first of all, get some education on it, but also to balance the power as that lower graphic kind of gets back to more even. And so they're going to stop, or hopefully they're going to stop. And they're going to, I guess, get eventually their version of punishment for that if they keep having these experiences.
Yeah. And actually recently, since we had lots of cases, different clients with issues with those maintenance or damage fees, either that they paid or were asked to pay. I personally wrote to that paralegal from one of the company we hear a lot, just to try to engage in some sort of conversation. Like, first, do you know that the company you're representing is doing that? Maybe she's not, because it's just a big company and just receiving paperwork that she files to the LTV. Or if she's aware, like, can we engage in some sort of conversation? Maybe you have a position which is different than mine, but at least we can have a conversation on where things are going and why we think it's not right. And also it will avoid time and money to everyone, and delays at the LTV are long, also because there are too many files. So if we prevent all those files from going to the LTV, because at first we are able to deal with it and avoid those illegal fees, it's a win-win for everyone. So we're trying that right now. It's really at the beginning of the process, because we're able in the past year to kind of create a relationship with that company and negotiate a few settlements. So I'm hoping that through that now we build something that can lead to a conversation. We'll see.
File on the LTV, you really need to have
As soon as you contact us and you open a file with the student care, we take care of all of that. So you call us, we have a discussion, we of course provide information, we will provide documents, we will request, for example, the lease, if it's damages like pictures or invoice receive, or and then once it's received by us, we take care of drafting the letters and filing the proper form and documents to the LTV, so you don't have to deal with that yourself. And as I mentioned before, you no longer have to be a student when it proceeds. If it's like in 2 years from now, and sometimes people are even living somewhere else. So everything is online. Yeah, the LTV, everything is virtual. So that helps a lot as well, because you can be anywhere on the planet, and 2 years from now still show up and with us, and we'll just present your case.
Luckily, we'll eventually realize that all of Waterloo students have legal support to fight back on this. So they'll stop. Well, hopefully they'll stop. Yeah. Or less.
Yeah, and like you said, it's the balance of power, because they know they're big companies, they have resources, they have money, and they can be scary because they're big companies, and as students don't really know your right. You think that they know better because they're a company, they're a legit company, but it's not because they are that they're necessarily following the law.
from small stores to big companies, there is incorporate. Government records. So these
And where did you find that platform?
that's in China.
In China. Oh. Well, there, I think, for example, Novum is based in Montreal, and in Quebec there is a website, and they have other resources, but also for businesses. So if you're not satisfied with a business, you can file a complaint with them. And then you can go online and look for those businesses and if they had complained before, which is not really a big thing here in Ontario. Same with the landlord tenant board. Here, it's not really advertised. Hopefully with all the online portal that is coming in with the LTV, it's very Stone Age. It used to be like in the past year, they're slowly going to that because of COVID. Maybe it helped to go faster on that virtual switch for the LTV. So maybe at that point, because as I said, the LTV portal website is very good for all the guidelines and the forms and the description and what to do. But in terms of finding decisions that were ordered, or have a big books of decisions, but even there, it's only decision numbers. You don't have the names of the parties. So you don't know what one of those companies were found responsible for anything, because their name on there. So hopefully the practice will be changed in the future. But yeah, that would be great to have that kind of website. You can start that maybe.
I have 3 minor questions about raising rents. One is if your landlord proposes a new lease which raises the rent %, would you recommend? Because then they have to go and fill out the form and then doing that to raise the rent probably by 3.5%.
Yeah, yes, I would recommend to go in the month-to-month, because really if you want to renew your lease because you have important terms that you want to change, I don't have any example in mind, but if you're just staying in a unit as a student and you just want to stay there longer than the term, I would really recommend to go to month-to-month. And what is good about the month-to-month as well is it gives you more flexibility if you want to leave. Because if you go sign another term of a year, then you have to wait until the end of the term to terminate it with the form 60 days in advance and so on, unless you sign a lease, but you have to wait. While for the month-to-month, you only have to give a 1 month notice that next month will be your last month. So it gives you more flexibility. And there's no really downside as a student to go to a month-to-month. Your rights are covered by the RTA. The terms of the lease are the same.
I saw at the beginning of the presentation some of the rights that you get through the RTA isn't necessarily for. Does that include rent increases, or what is that?
The rent increases it's something it's provided by the RTA, like the guidelines and how they can and cannot increase the rent. So if you're in a situation, a rental situation that is not covered by the RTA, so student housing co-op or student residence, then anything that I discussed today wouldn't apply. As I said, that being said, you still have a contract with someone, so that would be contractual law relationship. So contract law, where you apply what you agreed upon, and then if you breach it, you can file a claim at a small claims court. But anything we specifically mentioned today is only for the rental property covered by the RTA.
Okay, so for instance, if your landlord did give you a contract which was not the RTA form, which is the 728.
Yes. So the form that you sign doesn't decide whether or not you're covered by the RTA. So the RTA is the act, the legislation. The form is just the piece of paper providing the condition and the terms of your relationship with the landlord. So even if they gave you a piece of paper, they wrote on their kitchen table, you have to look at what is your rental situation? Are you living with the owner? No. Are you in a student residence? No. Am I in a housing co-op? No. Okay, well, am I in a short-term rental like an Airbnb? No. Then it's a rental unit. That is covered under the RTA. So this piece of paper is not the proper form, and I will ask for the proper lease.
Okay, so if you have been living in a unit and you didn't sign a lease, you can ask for a proper lease. Are you still covered under the RTA before you sign the proper lease form?
Yeah, it's not the paperwork that will provide whether or not you're covered, but maybe if you fall into this section of the legislation.
Thanks so much.
Are you the German president line in case of capital improvement? But they still have like a certain amount of communication. Like, if they could communicate.
Good question. That would really be based on case law, I'd say. So other decisions. So as I mentioned before, like all the decisions from the LTB are not advertised a lot, so it's hard to find, but there are books out there, which we have. You don't know who the parties are, but you see what the court could have, like the board could have decided in the past on those specific terms. So like undue damages, what is undue damage? What is negligent? And in this case, what is capital improvement? What is proper communication? All those things could be found in the case law. It's like a specific situation we could discuss further, but yeah, it would be mainly where we could see if whether or not they're following what they should do in terms.
Two questions, one for general, one for general one. I know like 5 or 6 years ago,
Well, I think if you speak with landlord, they will say that it's tenant, and if you speak with tenant, they will say it's landlord. And again, because of the publicity of the decision, it's hard to see a trend in terms of who the board member was. Sometimes they're more prone to finding to one or the other party's favor. Also the company and so on. So it's hard to tell. Of course, the big discussion right now is about the delays. There's actually an investigation by the Ontario Ombudsman on all the delays and how it affected people's rights. Since last year, they've been saying that shortly the report will come out. It hasn't been shared yet, but I don't know. I couldn't tell. It's really based on your case, I'd say.
okay, so
Yes. And also because of the delays right now, the main thing we hear on the news, for example, it's complaints from landlords saying I have a bad tenant and they are not paying me and I cannot evict them. I need that order. And it's been 2 years. So it's mostly what we hear on the news right now and reports, and it's mostly landlords oriented. I don't know if, as I mentioned, like if you have damages in your building and it's an old building that needs to be repaired, as a tenant, like what are your choices? You file, but you wait, you put up with it, or you move out. But with the rental market right now, where are you going to find a new rental? And if you do find a place, it's going to be super expensive. So tenants are still placed between like a rock and a hard place. And
my apartment lights up in water. Holidays. I was curious where our landlord did was he gave us like By the way, those damages, it's your fault for damages. I was offered for a
or you don't have any obligation to stay put in your apartment just in case. We're gone for 3 months during winter time. You didn't tell anyone and left your plumbing, like all like your sink, your faucet open, and you from like it's not the situation here. So I mean, no, you cannot be held accountable because you left for 2 days during holidays. And since you already came to a resolution, well, I think from what you're telling me, both parties agreed to, okay, this is the amount that I'm owing you when call it a day. You cannot come back in 6 months and say, by the way, I would increase your rent more because of that. I had to pay you 3 weeks. They have to follow guidelines.
Okay, awesome. Just in kind of
Actually, it's pretty good that you were able to get that.
what would you do for a
And correct me if I'm wrong, but you can access the program and like talk to Catherine or her colleagues to like kind of go over that situation in more detail and at very least like have maybe there's something that could fall into that. So anytime there's a doubt, contact the program and at the very least the legal professional will say yes or no, or it was right or it was not, and so on. So even things that already happened, or even if you don't think there's an issue, but you know, submit your lease saying, is this okay?
And it's free. And what's good also, it's not just like legal information. So today it was mostly legal information, like, but it's really case by case, looking at the paperwork.
Thank you. Yeah, I'm not in the way. I just had a question.
Yeah.
Sorry.
No problem.
Everybody else.
Except you.
Questions, I guess we'll end it here, but at any point, you can reach out to me, to anybody at the association, to the program. I mean, we'll all direct you to the program, but the lawyers are here to help. They're in your corner, they're on your side. So don't, any doubt, reach out.
That's an exciting.
Thank you.